Well, the case that comes to mind first is State v. Chandler. Dana Chandler was convicted in 2012 of a 2002 homicide, double homicide, Mike Sisko and Karen Harkness. The case went cold for 9.5 years, and Mr. Taylor got in office and assisted 48 hours to do a couple of shows, totally impeaching her in every possible way you can. And that concerned me because it's kind of like prepping the jury pool before you bring the case. That was in 2009, and they arrested her in 2011 and then convicted her. And the case has a whole series of problems. And I think the best evidence of that is January 27th, 2016, the Kansas Supreme Court heard oral arguments in that case. And they questioned Chad Taylor's chief of deputy, Jackie Spradling, about all the examples of prosecutorial misconduct she committed in this case, and there was 5 of them, and they were very serious. They were material, points on which the case hinged, and the way I would do it differently is I would order all my prosecutors, they're never to tell a jury something that's not true. I mean, that ought to be at the bare minimum. I mean, we all learned that in grade school. But, you know, in a prosecution, it's even more important. The case also has some investigatory problems. There were fingerprints, 16 fingerprints in that case that don't belong to either the victims or to Dana Chandler. There was DNA in that case that didn't belong to either victim or the Dana Chandler. And there was also an arm hair that was attached to a shell casing while the shell casing was still hot. And they had that for they had it right up until 6 weeks before trial when Ms. Spradling decided that it would have to be tested. After all that time, that hair came back with a DNA profile, and it wasn't Mike's, Sisko's, or Karen Harkness's, or Dana Chandler's. So they didn't follow where the evidence led. They followed, you know, what they had said in 2009 on TV. And that case should have been fully vetted, so to speak, but they all believed, they wanted to believe it was Dana, and then disregarded all the other evidence. And all the evidence has to fit. That is evidence in case, it's got to fit someplace. But they did virtually no investigation of who this DNA, who this hair belonged to. And so, you know, unfortunately, when you have a case like that, then you have to make up facts. And no prosecutor worked for me that has to make up facts. We got to get convictions within the confines of the Constitution. It's a denial of due process when a prosecutor lies, just like when a police officer lies, like Aaron Thompson, 612 cases. There has to be a separation between the DA's office and the 2 or 3 law enforcement agencies for which they get their cases. And they have to do a critical review of each one of those cases to make sure each case meets the elements. If it doesn't meet the elements, it's got to go back for reinvestigation. If it meets the elements, then we prosecute it fully. But we don't take a case where only 4 of the 6 elements can be met and then inference stack the last 2 elements. The Supreme Court refuses to accept that. They reverse cases where that occurred because it's a form of prosecutorial misconduct. So that's the principle I'm going to reinstill in all the prosecutors in my office, in my administration, that bear the work for me. No, it's not. Unfortunately, the county commissioners have trimmed the budget. The budget was $80,000 less in 2016 than it was in 2015. I know they have budgetary pressures, but keeping people safe has got to be a high priority, and it's got to exceed the priorities where they use that $80,000 for something else. We need more prosecutors. We need specialty prosecutors, especially in sex crimes and child sex cases. We need somebody who is an expert in that field, and that costs money. Those people aren't cheap. They know what they're worth, and we have to fight for an increased budget authority. Also, Aaron Thompson, 612 cases, that's a 20% bump in all the cases that are going to have to be reviewed, and some of them are going to require new trials, and it's going to take more prosecutors than we got now. So the budget is 3.7 and some change now, 3.7 million. We're going to have to get that to about, you know, 3.85, you know, and above, in order just to meet the demand that's coming in. And I hope, you know, Chad Taylor's building the budget now for 2017. It is my expectation that he really makes a case to the county commissioners for more budget. Absolutely. As a matter of fact, in 2014, the Kansas legislature passed a law that allows public to get affidavits for arrest warrants and search warrants. And there's kind of a two-tier system. Those affidavits are executed prior to July 30th, 2014. They get those by making a request. Those that are executed afterwards, the county attorney or the DA has an opportunity to at least have a hearing, object, redact. But you know, when a law enforcement officer submits an affidavit, it ought to be open to the public. That's why we have the Aaron Thompson perjury trial now, because nobody was looking at her affidavits. If it was open to the public and the public could get them as a right of transparency under CORA, actually it's not under CORA, it's under the statute, but it's a similar thing, is the DA's office has to be totally transparent. And if these affidavits are open to the public, then they can read them. A lot of times the newspaper will put them as a hyperlink and they can go read them. And that's a citizen review of their government officials, and it should no longer be secret. There should be no secrets in the DA's office. And that's one thing that I was very pleased that the Kansas legislature did that. It's something necessary to keep everybody on a even keel, meaning that we know there's not falsehoods put into a affidavit, and the public can see it, and if they see one, they can quickly make a citizen's complaint or contact the sheriff's office or the DA's office and says, I know what was in that affidavit is not true because, for example, if the guy was with me or he has a verified alibi, that's a good public policy.